Good afternoon, and thank you for joining us. I'm Bridget Anderson, the President and CEO of the Greater Vancouver Board of Trade. Today, we are gathered on the traditional territory of the Coast Salish peoples, the Squamish, Musqueam, and Tsleil-Waututh. And welcome to our Business Resiliency series, Navigating COVID-19. Today, we are focusing on labor and employment law. In this time of unprecedented uncertainty, we want to ensure our members and the broader business community can get the answers they need to their most pressing questions. Through a series of free webinars, experts will provide guidance and answer questions to help companies navigate these challenging times. We encourage you to take part in this discussion. You can engage with us on Twitter, Facebook, and Instagram using the hashtag GVBOT. And we're also using Slido for today's discussion to allow you to submit questions. Go to slido.com and you can see the password there, GVBOT employment. Before we start, and especially in these challenging times, we want to thank our long-standing partners called our Pillar Partners. They include TELUS, CN, YVR, BCIT, and Air Canada. We are very grateful for the support of these 5 organizations whose annual partnerships and sponsorship allows us to do our important work. Thank you as well to our preferred media partner, Business in Vancouver. Today, we are joined by Chris Beneteau, associate from Fasken. Chris is a labor, employment, and human rights lawyer in Fasken's Vancouver office. He has experience in both private and public sectors on a wide range of labor and employment law matters, especially important during this pandemic. And Chris has appeared before all levels of court in British Columbia, as well as before the BC Human Rights Tribunal, BC Labour Relations Board, and in labor arbitrations and mediations. Thanks very much for joining us today. Nice to see you, Chris.
Thanks very much, Bridget. It's my pleasure to be here and offer whatever guidance I can for businesses during these challenging and unprecedented times. I'll be talking today about navigating labor and employment law issues during this period, with a particular view to the impacts of various government announcements, but also generally. After that, I'll do my best to answer some audience questions, which is the lawyer equivalent of trial by combat, and something that I'll admit to being a little bit nervous about. Why am I nervous? Well, first of all, there have been and continue to be a lot of government announcements. Next slide, please. Let's start on the federal side. You may recall, though it seems like a long time ago now, that one of the first steps taken by the federal government was to expand its EI programs. Individuals isolated or quarantined due to the virus would be covered under sickness benefits without a medical note. It seemed fairly progressive at the time. Then, of course, the schools closed and the layoffs started rolling in, and it quickly became apparent that a lot of people were going to fall through the cracks of the existing employment insurance program. And so the government introduced the Canada Emergency Response Benefit. That program provides for up to $2,000 per month for people affected by COVID-19, regardless of their eligibility for regular EI. So that covers people in self-employment type situations or people unable to work because of childcare issues. More recently, on April the 15th, the federal government announced a top-up initiative for low-income essential workers earning less than $2,500 a month. The details of this program are still to be determined. Next slide, please. For businesses, the most significant announcement has been the introduction of the Canada Emergency Wage Subsidy, which subsidizes eligible businesses for up to 75% of employee remuneration, up to $847 per week per employee over the 12-week period from March 15th to June 6th. Business eligibility is determined based on a year-over-year gross revenue drop in each of March, April, and May. In March, it's 15%, and in April and May, it's 30%. The government has also doubled the length of its pre-existing federal work-sharing program from 38 weeks to 76 weeks. This program is designed to avoid layoffs by having employees share jobs and having the federal government top up their income to about full-time hours. The federal work-sharing program does require an application. There's also the 10% temporary wage subsidy for eligible employers. This eligible employers include individuals, Canadian-controlled private corporations that were eligible for the small business deduction in the previous year, nonprofit organization, and charities. The period for eligibility for this is March 18th to June 19th. It is up to approximately $1,400 per employee to a maximum of $25,000 per employer. And there's a whole host of other initiatives in the form of loans and rent assistance. Next slide, please. There's also been some provincial initiatives. The provincial government introduced a COVID-19 protected leave under the Employment Standards Act. This provides for indefinite leave for illness or for caring for eligible persons as a result of the disease. This includes childcare reasons due to school closures. There's also the emergency benefit for workers, and that involves a one-time payment of $1,000, and it's conditional upon the receipt of employment insurance or the emergency response benefit. There's also BC hydro credits, as well as the deferral of property taxes, at least in the city of Vancouver. Next slide, please. So, like I said, there have been and continue to be a lot of government announcements and programs, and I haven't come close to covering them all. Not all of them have to do with labor and employment per se, but that doesn't mean that they aren't relevant or potentially helpful for your business. So if you haven't already, I strongly encourage you to visit Fasken's COVID-19 Knowledge Center website and to sign up for our COVID-19 distribution list. Our talented team of lawyers from across the country have put together some very helpful information for employers. Not only can you see the full scope of government initiatives from across all of the provinces, but you can get more detailed information about the initiatives I just talked about, including the wage subsidy and the federal work sharing program. Best of all, it's 100% free. And if you decide you need help deciphering or implementing any of it, please feel free to email me or any of my colleagues, and we would be happy to assist. Next slide, please. So why am I a little nervous about the Q&A? Well, as you will have gleaned, there's a lot of information to digest for labor and employment lawyers out there right now. But that's not the only reason. You see, not only is there a lot of new and changing stuff for us to know in order to explain it all to you, but there's also a lot of stuff that we don't know with certainty. And we should talk to you about that as well. So what is the impact of COVID-19 on labor and employment law in this country, specifically under all of the listed areas there? Well, the reality is we don't know with certainty. The fact is the law as we know it today developed in a world free of the kind of social and economic disruption that we're currently experiencing. The law can and normally does evolve over time, and it is almost certain that it has or will evolve as a result of COVID-19, even if we don't fully grasp those changes right now. Let me touch on at least a couple of examples. So prior to the current situation, if you'd have asked me, can I temporarily lay off employees to save cost? I and most employer-side counsel would have told you that doing so would, in most circumstances, allow an employee to treat that move as a constructive dismissal. Is that still true? Possibly, but I'll say that an employer is normally understood to have greater flexibility to reorganize its workforce in the face of economic pressures. And how far does that get you here? Unclear. Another example is notice period. In the absence of a lawful contractual clause prescribing entitlement to notice of termination, an employee is entitled to reasonable notice. Well, what is reasonable notice during and post-pandemic? Is it more or is it less than it was before? Certainly, it'll be harder for an employee to find work, and this factor tends to increase the notice period. But on the other hand, notice period is not based off the period required to allow an employee to find new work. It's based off of what the parties would reasonably have had in mind at the time the contract was formed. There's even old case law that suggests a lower notice entitlement is due where the employer faces undue economic pressures. The reality is the fallout of COVID-19 in the area of labor and employment law won't be fully understood for at least 3 or 4 years as the cases emerge and wind their way through the courts. The challenge is you're having to make important decisions right now. And you might think, great, the lawyer doesn't know what to do, so I'll skip the consult and go it alone. Acknowledging my bias, I would say that's a bad idea. It's more important than ever to talk with your legal counsel, internal or external, to understand and appreciate the uncertainty and the risks of your decisions in particular circumstances. The idea here is you probably don't want to be the test case, or if you do, you want to make sure that your facts are good. It's important to remember that the limitation period for claims in British Columbia is 2 years. And so, assuming the economy returns to normal at some point during that period, you should expect there will be a host of plaintiff-side counsel ready to pounce on decisions that you make today. And so, the next slide, please. With that, I will do my best now to answer whatever questions, Bridget, you might have, and whatever audience questions that might come forward.
Thanks very much, Chris, and recognizing that it is a fluid situation and there's lots changing and a lot of unknowns. Yesterday, the Greater Vancouver Board of Trade announced and released survey results that showed over half of our members aren't feeling confident that they're going to be able to reopen when some of these restrictions are eased. And so obviously there's a lot of very difficult decisions that our members and members of the broader business community are having to make right now. So for those that aren't eligible for the wage subsidy or don't feel that they're going to have the revenues in place once restrictions are eased, and they are in that very, very difficult place of having to make decisions to lay people off, what are some of the things that they should know about how to go about that and that would be different under this pandemic than prior to this?
Certainly. So it's important to understand in British Columbia, employment is governed by the Employment Standards Act. And that act contains a definition of what's considered a temporary layoff. And basically a week of layoff is when you earn less than 50% of your regular earnings. And a temporary layoff is allowed for it constitutes 13 weeks out of 20. So the idea there is there's this period of temporary layoff before it's deemed to be a termination of employment. Now, unfortunately, the case law in British Columbia prior to the pandemic is that unless you have a clause in your employment contract, or unless you're in an industry such as logging, where seasonal layoffs are normal, there is no general unilateral right to temporarily lay off or put employees on unpaid leave. That amounts to a fundamental breach of the employment contract and can give rise to constructive dismissal. That said, drastic times call for drastic measures. A couple things that I think go towards mitigating some of that risk. The first is, what is the employee going to do? The reality is they can't, the employee is unlikely to be able to say, okay, I refuse to accept this temporary layoff. I demand you pay me severance, whether that's employment standard severance, whether that's contractual severance, or whether that's reasonable notice severance, whatever that amount is, and then go off and find another job right away. So there's likely to be more flexibility in terms of employees not wanting to trigger constructive dismissal. The other item is that this is fairly unprecedented, and as I mentioned, employers are generally understood to have greater flexibility in severe economic circumstances. And so, is there going to be at some point a COVID-19 exception to the general rule that you can't unilaterally lay someone off? Maybe. So you mentioned there may be ways to avoid a layoff. You're going to want to investigate your options in terms of the wage subsidy, where the government subsidizes up to 75% of the salary, up to a certain amount, depending on the nature of your workforce. That may or may not be viable. There's also the federal work sharing program. And again, that's where you're reducing an employee's hours and having them share jobs to a certain extent, and the government pitches in to keep them whole or close to whole. In the event of a layoff, the employees are entitled to up to $2,000 a month under the CERB, and they're likely entitled to $1,000 payment from the BC government. So there is a social safety net there for your employees during this time, which should ease some of the emotional concerns that you're going to have about doing that. But these are challenging times, and you're going to have to make some challenging decisions.
It's also important to note too that under BC's Employment Standards Act, that layoff period is 13 weeks. In Alberta, they have made some decisions to extend that, and certainly the Board of Trade and other business associations have been advocating on behalf of members and businesses to see that extended to 16 weeks. The BC government has not done that yet, but it is something that is being considered.
Yes, I've heard that as well, and we're hopeful of that. And it may just take time for the government to wrap its head around this situation and come to terms with that.
So let's continue on this thread if we could. Employers are having to make a difficult decision to lay off some of their employees. What are some best practices, recognizing that many of us are working from home, that usually in a time where there's layoffs or terminations, that this is done, with a lot of sensitivity, and it's done face to face. Now with physical distancing measures in place and people working from home, what needs to be top of mind if you're going through this process?
Absolutely. So Not a fundamental change here. Whereas before you wanted to meet with employees in person and be respectful about that process and sensitive to the emotional challenges that come with such a decision, the same applies here. So whereas you can't pull someone into an office or have supports people there to work with that process, you're going to want to pick up the phone. You're going to want to have a video call. You're going to want to have those difficult conversations face to face, or as face to face as possible. You're going to also want to make sure that you're clear and unambiguous about what exactly is going on. General practice rules: notice is better than no notice. So if you can give an employee 2 weeks to allow them to arrange their financial affairs, that is a good thing. And finally, if you are contemplating changes short of a layoff, the general rule, again, pre-COVID, is that pay decreases up to 10% as a general rule of thumb. So decrease in hours of work or just a decrease in salary of 10%. Those are generally allowable without triggering a constructive dismissal, but amounts normally above that would. And so once you've done that respectful conversation and once you've sort of canvassed your other options and you've decided to make the layoff, the strongest piece of advice I can have is make sure you're setting it out in writing. You're going to want to put key information, so preferably vetted by counsel. So you want to include the temporary date of the layoff or the effective date of the layoff, whether it's a temporary or it's a permanent layoff. Clarify what's happening to employees' benefits during that period, how they should go about getting their record of employment, whether that's electronically or whether it's going to be mailed to their house. You want to include contact information for someone at the company and any sort of time frame for the company to get back in touch with them. One final thing I'll touch on is if one of the, I won't call it a loophole, but one of the mechanisms by which a temporary layoff is strictly speaking allowed under the Act is if employees consent to it. Now, that's sort of a mixed bag. So if you give the option for employees to consent to the temporary layoff and they do, that's great, and you're probably shielding yourself from a degree of risk that the temporary layoff is a constructive dismissal. On the other hand, if they don't agree to the layoff, then that heightens risk, and so basically you're going to want to consider the scope and relationship with your workforce. If you're a smaller employer and everyone understands what's going on and you expect to get a lot of yeses, great. If you're in a different workforce or a larger workforce, asking for consent may not be the way that you want to go, just because you're probably not going to get the results that you want out of it.
Great, thanks very much, Chris. Now, for those employers who are thinking about the 75% wage subsidy, we did hear from the federal government that the portal will be open on April 27th, so that's next week, and then some of the processing should be done by about May 4th and direct deposit sometime after that. That's still a little ways off though, and according to our survey yesterday, a lot of businesses saying they're running out of both money and time. So any thoughts about what could be done even in the next 10 days or 2 weeks until some of these funds reach these businesses?
Sure. So one of the things you're going to want to be aware of with the wage subsidy is that one of the prerequisites for eligibility is that employees have to can't have been without remuneration for more than 14 days during a period. So what you might consider temporary, rather than temporary laying off your entire workforce, you're going to want to consider things like reducing hours, reducing pay on an interim basis, as well as even rotating layoffs, just so no one falls in that excess of 14 days. To the extent you can make changes to keep your business operating to a certain degree, that will improve your chances of being accepted for funding under the wage subsidy.
Okay, great. Well, let's go to some questions from Slido. I know that this is a topic that many businesses are really grappling with right now. So I think there'll be lots of questions here. And let's start out with this first one is, and it's really around the Employment Standards Act. So do you expect that there is going to be an extension of this 13 weeks? And I can speak a little bit to that it's something that the Board of Trade is advocating on behalf of businesses and speaking to the BC government about it. We're waiting to hear, but maybe you could add some comments there. And then also there's a secondary question about whether companies have to pay severance after 13 weeks. And so I think the question here, though, is severance, which would indicate a termination, not a layoff. So maybe you could talk a little bit about that, just to clear that up.
Certainly. So under the Employment Standards Act, a temporary layoff is deemed to be a termination, and severance is due after 13 weeks. There is also a provision under the Act that allows an employer and employees to request an extension to that period. So there is the ability to extend beyond that 13 weeks, but it requires writing to the ministry in order to get that authorization. Do I think it's likely that they will? Don't want to get myself into trouble here. I don't have a crystal ball. I think they have to. This is not a 13-week disruption, and so they're like, the courts are going to have to grapple with the question of an employer unilaterally imposing the layoff, and the legislators, the politicians, are going to have to grapple with that 13-week period. Technically, severance is due. If you don't pay it, it's incumbent upon employees to file a complaint and then treat their employment as at an end. As I mentioned earlier, that doesn't seem, speaking as an employee, that doesn't seem to be a particularly wise move to do. And so the employee continues to be eligible for CERB or EI during that period. So they do have a social safety net. So the answer is technically yes, you would have to pay it as it's currently drafted. But hopefully there's some changes on that front, and there are options available to you to extend that period to fall under strict compliance. And again, there's always the fingers crossed approach and hoping that employees do not choose to exercise that right, because then they will be out of a job, which is not what any of us need at this time.
Great. So organizations that are looking at the work sharing program, how can they implement that effectively when they're doing it for the first time? Have you got thoughts about that?
Absolutely. I'll direct people again to the Fasken COVID-19 Knowledge Center. I will admit that is a program that I was not particularly familiar with until this time, and I think that's fairly true of most people. But there's an application process. It was designed in a pre-COVID era to really be an exceptional relief or subsidy fund for employers to keep people working, and the government would pitch into that. The administrative process has not shifted or streamlined in any which way, shape, or form. So you're still going to have to follow the same process, and it is fairly rigorous. I believe the materials we have on our website are fairly helpful in that regard, but it is the sort of thing that in order to ensure your chances of success, you may want to consult external counsel. Yeah.
And I think I noticed on the eligibility that work sharing has to be within a same department. You couldn't have work sharing with maybe an accountant and a lawyer, for example. So I think there are some pretty strict guidelines in there.
There are, and you can reorganize your workforce in order to make them fall into those sorts of things. There's limits on the amount of earnings that the government will top up to. You should also know, for those of you in small businesses, that just because you're the owner or the head of a business doesn't mean you're not eligible under that or under the CERB. So there's lots of information that you need to check out in preparing your application and understanding what entitlements you might have.
Great. And in addition to your resource page, we also have links on our resource page of the Board of Trade to a number of these government programs. So you could either check out either one of those. So a good question here. I think there is a lot of fear out there about people getting sick. And so can somebody say that they don't want to go to work because they are concerned about COVID-19?
Excellent question. There is a right in British Columbia and in all provinces in Canada to refuse what's called unsafe work. There is a very specific process for that. My suggestion is if there's a particular concern, like if you operated a hair salon and you were to reopen, the plan was to reopen in exactly the same manner as you were operating in February. My suggestion would be that, yeah, the employee would be within their rights and would be right to refuse unsafe work. And you would face risk as an employer if you compelled people to return to work in those circumstances. For most for the more general concerns about I don't want to leave my home or I don't want to show up in the office, even if there are social distancing measures put in place, no, an employee does not have the right to refuse to return to work out of a general or a non-specific fear. How you deal with that as an employer, as you're going to want to talk to them about that. You're going to want to explain to them that they are required to return to work within a reasonable time. It may not be, you don't want to do it on an hour's notice, you don't want to do it on 24 hours notice, you want to give as much notice as possible. But you do want to inform them that if they don't return to work, they will be deemed to have quit. And if they are deemed to have quit, then they won't be eligible for CERB or for EI, which is obviously a concern for individuals. This is also a concern for people who might be happy to remain at home and earn the money. So a less than honest concern about the safety of the workplace. So these are the sorts of things employers are going to have to deal with. Be patient and just be clear and set yourself up for, in terms of a paper trail, showing yourself to be reasonable and measured in your response.
And then what about as an employer's responsibility or some ways that employers can help deal with individuals' apprehension on returning to work around when some of the restrictions start to ease and some businesses start to reopen? How do employers deal with some of that fear and apprehension?
Communication. Then that's not a legal answer. That's not a and I don't think there is a great legal answer. You know your employees, and you're going to have to find effective ways to communicate with them. Be honest. Allow them to listen to their concerns about how to make the workplace safer. These are unprecedented times, and ideas that may have been crazy before might not be so crazy right now. So listen, have those conversations, and do your best to ensure that employees are feeling heard, so that you're not being seen as a high-handed and callous business forcing people to return in what could be seen as an unsafe environment.
And certainly looking to the provincial health authorities as well and seeing what kind of guidance they're going to be giving to the business community about having the right measures in place to make sure that the health and safety of their workers is top of mind. So on that same thread, there's a question at the bottom here of the screen about those employers that are still open for business now. Are they obligated to provide the protective measures, whether that's hand sanitizers or masks, et cetera? Is there a legal obligation here?
There is no legal obligation to provide masks, hand sanitizers. There is a legal obligation to provide a safe workplace for employees. Where you want to look for, and that's a typical lawyer answer, and I apologize for that, but the way in which you're going to inform what does that mean for my workplace is you're going to want to look to things like the provincial health authorities you just mentioned. WorkSafe BC is also an excellent resource, and they're the entity that actually enforces workers' compensation complaints, or workers' compensation, as well as workplace safety complaints. So they have some excellent resources and industry-specific resources that give guidance on best practices during these times. And you're going to want to do your best to ensure that you fall within those guidelines that they're putting out.
We have time for one last question, and I really want to focus in on the CERB and EI because it's a question that I've been talking to a lot of businesses about as well. So can employees apply for both EI and the CERB, or how do they decide between which one?
So EI and CERB, EI has been increased. My understanding is that EI has been increased to the amount of CERB, and the processes are one and the same at this point. So CERB is up to $2,000, whereas EI at one point, it's just over 500. So they are distinct. So if you're entitled to EI, you should apply for EI. If you don't fall under EI, you should apply under the CERB. My understanding is there is some streamlining of those processes, and that as you go through the portal, they will direct you to which ones you should do. You won't get both. The federal government has been very clear that you will not get both, or rather, you will not get the sum of the values of those two things. You will get the greater of which you're entitled to, and that's the end of it.
Well, thank you very much, Chris. I know that there's a lot of questions by both employers and employees, and certainly I'll take a moment to give you a bit of a plug there, because I think anybody who's navigating these kinds of questions, it really is wise to get some outside legal advice, or if you've got some internal resources like that as well.
Thanks very much for having me today, Bridget.
Thanks very much, Chris. Stay well.
You as well.
And you are able to watch this webinar again if you'd like to. If you've missed part of it, please visit theboardoftrade.com and our COVID-19 page, and it will be posted there. And we'd like to continue this important conversation and stay connected, so we are going to continue our series of free webinars on navigating COVID-19. Over the next few weeks, we'll be bringing together experts to speak on cloud computing, and we'll also be joined by the Minister of Jobs, Economic Development and Competitiveness, the Honourable Michelle Mungal. And as mentioned earlier, we have created a business resource page, which is designed to provide information, links to different sources, and some toolkits as you are navigating the challenges that are associated with COVID-19. And you can find it here, you see on your screen, boardoftrade.com/COVID-19. Thank you, everyone, for being part of today's webinar. We look forward to seeing you again. And to echo the wise words of Dr. Bonnie Henry, be kind, be calm, be safe.